forth fingers of a man's hand, and wrote over against the candlestick upon the plaster of the wall of the king's palace, and the king saw the part of the hand that wrote. Then the king's countenance was changed, and his thoughts troubled him, so that the joints of his loins were loosened, and his knees smote one against another. The king cried aloud to bring in the astrologers, the Chaldeans, and the soothsayers. And the king spake, and said to the wise men of Babylon, Whosoever shall read this writing, and show me the interpretation thereof, shall be clothed with scarlet, and have a chain of gold around his neck, and shall be the third ruler in the kingdom. Well, certain judges on the Fifth Circuit seem to be saying that they are the astrologers and Chaldeans, and we'll hear about why that is today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. Now, we're recording this on Wednesday, December 20th, 2023, but it'll be going out shortly before the new year to round out 2023. Joining me today to bring the ball down on Short Circuit and this wonderful year we've had is my colleague, Joe Gay. Joe, welcome back to Short Circuit.
Thank you, Anthony. Thank you for inviting me back on. I'm happy to be here.
Of course, and it's a very happy day for Joe to be here because he actually had a victory in one of our cases this morning. We're not going to be talking about that case, but it's a First Amendment occupational speech case that y'all should check out. Any brief words to say about maybe that case or other occupational speech cases these days, Joe?
Yeah, well, I don't want to just celebrate our own victory. We also had another victory yesterday in Indiana involving giving end-of-life advice. And now we have a victory today in North Carolina. So it's been a very exciting and joyful couple of days here at IJ.
And it's a case about engineering speech. So someone being an engineer and speaking as part of their occupation, and whether this definition of what an engineer is should envelop them in regulation. And the funny thing is, I had my case before I came to IJ that I did as a volunteer attorney was about someone truthfully calling themselves an engineer, but they didn't have a license for technical reasons. That was against the law, and were actually prosecuted for that. So I'm glad that many years later, we're winning these victories in federal court on behalf of the First Amendment and allowing people to truthfully describe the events of the world. So whether or not in the book of Daniel, the events of the world were truthfully described, which was the reading I had at the beginning, we will go back to that in the Fifth Circuit a little later in the show. But first, Joe is going to take us to an old part of the Fifth Circuit, which since 1980 has been the 11th Circuit, and the story of anyone who's done anything to do with employment law over the years or discrimination law knows about what this case is going to discuss, which is the McDonnell Douglas test. It is the thing you learn about when you do employment discrimination law. And apparently most of us, including me, until I read this case, have been doing it wrong for a very long time now. So Joe, tell us about this case and what we're getting wrong with McDonnell Douglas.
Sure, happy to talk about this. And as the case makes clear, you're not alone in getting it wrong. Apparently many parties and many judges have been getting it wrong all along as well. So the case is called Hines versus Florida Department of Juvenile Justice. And it's an 11th Circuit decision. The panel is Judge Grant, joined by Judge Newsom and Judge Pryor. And the
Jill Pryor, we should say, right?
Yes.
Yeah, because there's two Pryors on the circuit.
More than one Pryor. And so this case is about it's a Title VII discrimination case, and it's specifically about how do you prove racial discrimination under the Act. And the Act, of course, as you mentioned, it prohibits discrimination in employment on account of race, color, religion, sex, or national origin. And before jumping into the facts, I think it's helpful just to set the lay of the legal land a bit. So when a plaintiff is trying to prove discrimination under Title VII and some other statutes that are in this constellation of employment discrimination statutes, obviously what they would really like to do is have what's called direct evidence of discrimination, right? Like the email that says, whatever you do, just don't hire a woman for this job.
Right.
Like that's really like what you would want to have. That makes your job as a lawyer very easy. But most cases aren't going to have that. And so they're going to use what's called circumstantial evidence. Something like an example would be like suspicious timing, where a woman gets let go a week after she tells her boss that she's pregnant. It's sort of suspicious timing. It's circumstantial. It suggests that maybe her sex, her getting pregnant, were the reason why she was let go.
Right.
And in practice, that gets really tricky because job decisions, hiring, not hiring somebody, demoting them, promoting them, they're made for a million reasons. Good reasons, bad reasons, stupid reasons, stupid but legal reasons, and illegal reasons, like race or sex discrimination. And so it's just like really hard to tell, just as a factual matter, why an employment decision was made the way it was and whether one of the reasons or the reason was something illegal. So along comes like this 1973 case, Supreme Court case, called McDonnell Douglas Corporation versus Green. And it basically invented a framework for what it called, quote, the order and allocation of proof in a private, non-class action challenging employment discrimination. And it's kind of an amazing decision if you go back and read it with modern eyes. Like when I say invented, I literally mean it, because there's no discussion about where the standard comes from. There's no discussion of precedent. There's no citation to precedent or the common law or the laws of procedures or evidence or anything like that. They just sort of go, this is kind of a tricky issue. The circuit courts need some guidance. Here's the law now. And they just say it. And that's how McDonnell Douglas announces this framework for resolving these cases that then has been the law with us for the past 50 years. But it's just funny to read it, and it is very much a product of its time.
Yeah, you would not have a case like that today, most likely.
No, I don't think so. And so the framework basically that it announces is that a plaintiff first has to make a prima facie case, which in turn has these 4 subparts. And in that case, it was, are you a racial minority? The language gets tweaked over time, like, are you a protected class? But at the time it was, are you a racial minority? Did you apply for a job that you were qualified for? Did you not get hired for the job? And then after that, did the position remain open and the employer continue to look for somebody to hire for the job? So that was the prima facie case that they announced in McDonnell Douglas. And if you do that, then the burden shifts to the employer to articulate some legitimate non-discriminatory reason for that rejection. And if the employer does that, then it goes back to the plaintiff, who has an opportunity to prove that those reasons are pretextual. And so that's your basic McDonnell Douglas framework for resolving these cases, which, as you said at the outset, like, it's super important. Like, employment discrimination cases is a huge portion of the work that the federal courts are doing. And they often are applying this framework from 1973 about how you resolve these kinds of cases.
And it adopted in areas outside of Title VII. I mean, you see it, I don't want to say infected, because I don't want to be pejorative here, but it is, used or adopted by in all kinds of areas. You might see it.
Yeah, I've seen it, for example, in age discrimination cases, in other kind of statutes that have adopted this framework. And I think, as you might not be surprised from the timing of when this case was released, I think it was intended to be plaintiff friendly. Like, you come in, you're a plaintiff, you don't really know why you didn't get the job. So you have this really easy standard of like, well, they didn't hire me for the job and I was qualified. And that creates your prima facie case. And then it puts the burden back on the employer, right? And so that, I think, as it was originally formulated, it's a very plaintiff friendly standard that's supposed to make it easier for you to kind of come in and make your case of discrimination.
Right. It gets your toe in the door, if nothing else. And then, it seems like you get closer to the fact finder at that point, whether it's the jury or the judge.
Yeah, I think that's right. But then kind of a funny thing happened over the next 50 years, which is that in different contexts, you then have different standards that you have to have for your prima facie case. And then what has often happened is they said, well, to make this initial case, you actually have to point to somebody who is similarly situated. And then, so to make that case, you have to point to somebody else who is not your race or your sex or whatever, who is like you but was treated differently. And then you can kind of see where the trouble's happening then with this standard, because there are a million different kinds of employment decisions you can make. It might not always be easy to point to somebody else who's similarly situated but was treated differently. And then the 11th Circuit a couple years ago said not only do they have to be similarly situated, but in a en banc decision by Judge Newsom, whose concurrence in this case we'll talk about a little bit later, said you actually have to be similarly situated in all material respects. So this standard that was originally designed to be this kind of plaintiff-friendly presumption that's going to help them along has now actually kind of become this obstacle that makes it really hard for plaintiffs to make their cases, because there might not be somebody who's similarly situated in all material respects. So it's just kind of an interesting way that this doctrine has evolved over the past 50 years, and the way it has evolved, I think, is irrelevant to how the facts and the law play out. In this case, Tynes v. Florida Department of Juvenile Justice. So with that legal background in mind, we can turn to the facts now, which I think are pretty simple as portrayed by the panel opinion, which is basically that there's a superintendent of a juvenile detention facility, our plaintiff, and she goes out on medical leave. And during that time, there's a number of incidents, and backup has to be called to the facility to help out. And that leads to a higher level official assembling a team, a technical assistance team, to look at the staffing and personnel issues, and they conduct this review. And after they do this review, but before they finish their report, this official basically fires the superintendent, our plaintiff. And the superintendent sues for race and sex discrimination. And she says, hey, there's this white male here and this white female here. They're also superintendents. They had similar managerial problems, and they weren't fired. They received reprimands. They were allowed to transfer. They were given chances to comply with recommendations for improvement. So they're like me, but they were treated differently. That's discrimination. And so then it goes to a jury trial. And there's some evidence that the technical assistance team was, in one witness's view, a search and kill mission against the plaintiff. There's evidence about maybe some technical inaccuracies in the reporting. But I think perhaps most importantly, the assistant secretary of the department who fired the plaintiff, who's probably your star witness if you're the defense, right? This is the person who's going to really explain what was motivating these actions. By all accounts, her testimony goes horribly. She couldn't even recall why she thought the plaintiff had engaged in, quote, conduct unbecoming as a public employee. And she couldn't point to any other employee who had been fired without first receiving negative performance reviews or getting prior reprimands. So I think, pretty bad for the defense.
Yeah.
And so based on all of this, the jury finds in the plaintiff's favor, awards her $424,000 in damages, $500,000 for pain and anguish, and the judge orders that she gets her job back too, with a different supervisor. And so the Florida Department of Juvenile Justice appeals. And given the evidence, given the jury verdict, you might ask, well, given that testimony, how are they going to appeal? What is their basis? And that brings up these McDonnell Douglas factors. The defendant said, look at these factors. She actually never met her prima facie case. And that's because, as I mentioned earlier, in the 11th Circuit, your prima facie case, it requires you to show your comparator was similarly situated in all material respects. And they said, well, perhaps this white male and this white female that the plaintiff pointed to, maybe they were somewhat similar, but they weren't similar in, quote, all material respects. So there was a failure to prove the prima facie case. And so judgment should have been granted to them as a matter of law applying these McDonnell Douglas factors. And the panel basically just smacks that argument down. And it says, and it reminds us that it has said so before, that McDonnell Douglas is an evidentiary tool. It's a procedural device that basically is establishing an order of proof and production, but it's not the actual substantive standard of liability that you have to prove. You only have to prove that you were discriminated against. These other factors, they're just kind of procedural tools to get you to that ultimate question. But the ultimate question is the only thing that actually matters here. And the panel points out that, courts have kind of talked about this in a loosey-goosey way before. And so, quote, parties and sometimes courts have missed that point about how you apply these factors. And they have treated the prima facie case as a substantive standard of liability. And it also notes that there's confusion as well, because oftentimes if you fail to prove your prima facie case, like whether there was an adverse employment decision, that means you've also just failed to prove your case in chief too. So there's all these kind of like pitfalls and like the language and the overlapping standards that have led courts and parties into error on this issue. But it basically just tries to make very clear that the ultimate standard is whether there was discrimination, not whether this prima facie case is satisfied or not satisfied. It points out, for example, that maybe you don't need comparators because you can prove your case using a quote unquote convincing mosaic of circumstantial evidence. And so in short, looking at the facts in this case, once there's been a trial, once all the evidence is in, you're kind of well beyond the point of looking at this prima facie case, right? At this point, you just have the full evidentiary record. You're just looking at, is there enough evidence for the jury to find that there was discrimination, or isn't there? And that's the ultimate question. And then the court concludes that because the defendant only argued about this prima facie case issue, it loses on that. And it actually forfeited any argument about whether that actual ultimate weight of the evidence was actually insufficient, because it focused on the prima facie case and not this ultimate burden. It actually forfeited the argument that mattered.
I think they could see the writing on the wall with that argument, with a jury verdict, which are very hard to overturn.
Exactly. So there was some harsh medicine there. And then I'm not going to describe it in detail, but less significant, it also briefly addresses the claim that the plaintiff hadn't properly presented their claims under 42 U.S.C. 1981, which also prohibits discrimination, may have impacted the quantum of damages that could have been awarded here. Basically, it says they forfeited any objection to amending at trial to include that claim in the pleadings to the extent they weren't in the pleadings. And then they forfeited any argument that the plaintiff didn't meet her burden at trial because they focused on the pleadings. So that's sort of thrice harsh medicine for the department here.
And this is kind of a very lawyerly point I'll just briefly bring up, but they talk about Rule 15 of the Federal Rules of Civil Procedure, which is about amending the pleadings at trial, which is something that I've never done myself or come remotely across. Because usually, if you actually are at trial, you're hopefully not trying to amend the pleadings. But it reminds you can do that, and it actually worked this time.
Yeah, and as far as I know, it had a substantive impact on the outcome.
And to be fair, it wasn't a complete surprise. It was just kind of sharpening what the pleading said. It seems.
Right. So anyway, so that's the majority opinion, which I think is just interesting for all the reasons we described, pointing out the way that judges and parties have been getting this wrong and pointing out the correct way to actually apply these standards. But what also makes this decision really interesting is that there's this concurring opinion by Judge Newsom that at 20 pages is actually a little bit longer than the majority opinion.
And I should add, talking about Judge Newsom concurrences is getting to be a bit of a side hustle for us here on Short Circuit. We've done this like a half dozen, it seems now, but this latest one is a real doozy.
Yeah, it's interesting. Part of what makes it interesting is it starts off by saying, it describes the kind of background of McDonnell Douglas and how it's been applied. And then it says, quote, "I've concluded that I was wrong about that," as in 180 degrees wrong. And then it goes through and explains why. And then it concludes saying, "I repent. I had it backwards." So maybe not often that you see that kind of maybe confession of error from a circuit court judge.
I appreciate the judicial modesty there.
Yeah. And so just briefly, the reason why he basically goes through and is kind of critiquing the McDonnell. I call it McConnell because there's so many like politicians and jurists named McConnell that it's hard to remember which is which. Right. The McDonnell Douglas factors, he's basically critiquing them and how they've been applied because he says, first, if you just look at it, it really just seems kind of made up. And that kind of gets to my point earlier about kind of how this 1973 decision is written. It is just made up. They just say this is the standard, but there's not really any justification about why it's the standard or why it should be the standard. They just say it. And it certainly doesn't come from like the text of the statute or any evidence or procedural rules. He calls it a, quote, product of its time.
And he likens it to Miranda, right? The Miranda warning, which I think was just 5-6 years prior.
That's right. And McDonnell Douglas, I mean, it's actually from 1973, and there's another decision from 1973 that I thought he might mention, but perhaps
maybe it's best for him to leave that out of the way.
Perhaps it's too soon.
Yeah, we're talking about Roe v. Wade for those who don't get the reference. But yeah.
His second criticism basically is that this sort of like minor decision about kind of this like procedural ordering of who presents proof in what order has sort of taken on this real outsized importance, especially in summary judgment decisions, where if you, for example, can't point to that comparator, then you're going to get bounced on summary judgment, even if you might conceivably be able to put together a circumstantial case that otherwise shows that you have made out a case of discrimination. And then third, he just thinks as a matter of first principles, he just thinks the summary judgment standard, which for non-lawyers basically is a motion you file before you get to the jury that basically says, if you look at the factual record, no reasonable jury could find in favor of my opponent on this issue. So the court should just grant judgment in my favor. And he says that's the standard that applies. That's a procedural standard that applies in every case. It's kind of weird that we've ended up with this weird quasi-summary judgment standard that applies only in discrimination cases, which is kind of like the practical way that it's played out with these factors on summary judgment. And he actually quotes Justice Kavanaugh from when he was on the D.C. Circuit, who said that actually in summary judgment, the framework should be, quote, almost always irrelevant. And then there's other precedent that says that it's not a pleading standard. And he points out that it's also not used in jury instructions. It's not used in your trial standard. So
where is it a standard for?
I'm left kind of scratching my head. Yeah, like what is left with this? It is, I think, probably properly cabined to like an occasional tool a plaintiff could use if they need it, but maybe not something that would otherwise need to be pulled out all that often.
And the funny thing is about McDonnell Douglas is, and I think this is how it became so popular, is kind of in the abstract without getting into all the details, especially that comparator requirement. It makes a lot of sense in some ways. So you can have a lot of discrimination claims. There are a lot of discrimination claims, and it's hard to tell the good ones from the bad ones because, as you say, you have to make inferences usually. There's very few smoking guns in this kind of case. And so to think that, okay, you got to come forward that you have a prima facie case, so you're a protected class and something bad happened to you, and then you go to the other side, well, we had a good reason. I mean, that all makes sense. It's just that it's just kind of a working tool, right? It shouldn't turn into this be all end all, which is both the majority and Judge Newsom's point, it seems. And so it seems there's a lot of value to it. It's just, one, it's not in the statute. or the rules. And two, you can't get hung up on it's like a lot of things in law. You can't get hung up on where it evolves and kind of turns into something else that it wasn't originally intended for. And it seems that it's gotten lost in the weeds in a sense.
Yeah, I agree. And one interesting thing I noticed when I went back and looked at McDonnell is that when they talk about the kind of last phase of the burden shifting framework, how can you show that this was pretextual? One of the examples that the Supreme Court gives is pointing to other similarly situated people who were treated differently. So the Supreme Court is originally envisioning like this, pointing to similarly situated people as one way that you would prove pretext kind of at the backside of this burden shifting framework. And then in more recent years, it's been used on the front end, the prima facie side of the framework to actually weed out cases before they can even get to that point. So,
yeah, because you can see how that evolution happens where courts, to get rid of their dockets. I mean, it's not a constitutional matter, but it's kind of a judicial engagement thing here and judicial abdication where you have a multi-factor test and the plaintiff has to meet all of them to then shift the burden. If that's the standard, then the court's going to be like, wow, I just have to one of these 4 or one of these 5 that find against them, and then I'm out of here. And so if it's similarly situated, there's a lot of equal protection law that unfortunately says you need to be similarly situated to someone else to even raise an equal protection claim, let alone whether it's justified, this difference in treatment is justified. And then similarly situated is often defined so darn narrowly that you just can't even bring the claim. We've had many cases at IJ where we've had that in a constitutional context. Well, this is kind of another example of that. And so a court has whatever you think of employment discrimination law, whether the current employment discrimination law is not good enough or is too narrow, you can see how a court trying to unload its docket is going to latch onto that and use it as a way to toss suits that maybe under the fair reading of the statute shouldn't be tossed.
Yeah, and one of the things that Judge Newsom says is, he advocates instead of taking this what's called a convincing mosaic theory, that is like this, what he called it kind of a hack, or what he used to think of as kind of a hack. Like if you just have a hopelessly losing claim, your Hail Mary is like this convincing mosaic theory of like these little tidbits of circumstantial evidence that maybe together are enough. And he just points out, well, these are actually, that's just called circumstantial evidence. It's not a convincing, take out the fancy language. That's not a convincing mosaic. That's just enough circumstantial evidence to convince a jury.
Right.
And so he's advocating that this should actually just be the main way we think about proving these cases. And one of the objections he looks at that people might have is, well, maybe this will overburden the courts. And his response is kind of basically, big deal. It's not our job to have this as a policy matter that we think courts have too much work to do. We should just try to get the law right here.
Right. One other tiny part of this case I thought was interesting was going back to where I raised the Rule 15 earlier, is not only have I not really dealt with Rule 15, but apparently counsel for the defendant hadn't heard of it and was asked about it at oral argument and didn't know what it was, which I have no idea if it was excusable or not. Of course, you could ask all kinds of crazy stuff at oral argument that counsel don't know, but that's not a good sign if oral argument's going for you like that.
Yeah, I suspect the way this played out is probably a little bit more defensible for defense counsel not to have known this, because this is not something that lawyers have to deal with very often. But yeah, certainly not a good day to have that both come up in oral argument in that kind of way and then make it into a published decision.
Right. Well, something else, if you are defense counsel, you don't want to come up. Well, actually, counsel for either side is when you are arguing your case and then you receive your opinion from the appellate court, is you win, and then the court says, but we think this raw is long, and we immediately call for en banc review. And then actually that review is granted. And so that's what happened recently in the Fifth Circuit. And it's the case that I'm going to be talking about this week. And it is, so we'll talk about the panel opinion. So that's the 3-judge panel, that reviews appeal from the district court in a normal appeal. And then it gets to the en banc court, and that is the full court of appeals that can correct what that panel has done, and also gets into this thing we talk about sometimes on Short Circuit called the rule of orderliness, which is where a circuit court, so First Circuit, Second Circuit, Fifth Circuit, whatever, they are bound by their previous 3-judge panels, even though 3 judges is not nearly a majority of the whole circuit. They are bound by those decisions, the precedent in those decisions, and unless it's super clear that the Supreme Court has told them they're wrong, whether it's that an appeal from that court or somewhere else, but it has to be really clear that the Supreme Court has said that that ruling was wrong by implication, or the court itself can do it through the en banc process, where you get all 12 or 15 or however the Ninth Circuit does it. It's a weird process there because they have 29 active judges to reverse itself. So I'm not going to go too into the facts of this case. It is a Voting Rights Act case, but just very briefly, it is a challenge under Section 2 of the Voting Rights Act. Now, we talked about a case under the VRA Section 2 a few weeks ago in the Eighth Circuit about whether private parties who aren't the Attorney General of the United States have a private cause of action under Section 2. That hasn't come up here because the United States is one of the parties. Now, there are some private parties involved too, but it's just not part of this case. It shows you how the VRA isn't just about, congressional seats or even the state legislature. It covers a lot of stuff, and that includes the Galveston County Commissioners Court. So the Galveston County in Texas Commissioners Court has 4 county commissioners, and then it has a county judge elected by the whole county. So there's basically 4 precincts, or 4. They call them precincts, but you might call them wards. And so they have to change the maps every census, and for the last few decades, there has been a majority-minority district. So that is a big thing under the VRA, that if you have a majority-minority district, you're not supposed to redistrict to get rid of that district or districts. This was a big deal before the Supreme Court last summer, where they thought the Supreme Court might find part of the VRA that mandates this unconstitutional, but it was upheld with the 2 of the usually conservative judges, the Chief and Justice Kavanaugh, voting with the more liberal justices. And so it's still the law. And so this is a challenge to a redrawing of the map that got rid of that majority-minority district. So that was a challenge. The district court found the new map not unconstitutional, invalid under the VRA. And so there's an appeal for that. Now, here's the issue. The district is majority-minority only if you add up the blacks who live there and the Hispanics who live there. So the whites who live there are not a majority, or whatever other races are involved, but they don't talk about that. But if you add blacks and Hispanics to get together, you have 58%, so majority-minority. Now, there is precedent in the Fifth Circuit saying that that is okay under the VRA. However, there's a circuit split on this, and the judges in the first panel thought that that's wrong. That actually, if you read the VRA, they use the singular, so it's really just supposed to be about the political, right? You have a political identification of a minority population that has a majority of the district. If you just cobble together minorities, that's not really what the VRA is supposed to be addressing, right? You can argue that, but that's what this panel thinks. Now, the problem is there's this precedent. So the 3-judge panel, which is Judge Jones, Barksdale, and Elrod, they issue a per curiam opinion. So that's an opinion where none of the judges sign their name, and so you don't know who it's by. It's just kind of by all of them, basically. There's no noted dissent, and they say, yep, the district court applied the right law, and so we're affirming the district court. But as I said, they say that we think that law is wrong. And I don't know if I've ever seen an opinion that says its own precedent is so wrong. I mean, you potentially could, but it's pretty darn clear that they don't agree with that. And so they actually end the opinion saying, the judgment of the district court is affirmed. We request a poll on whether this case should be reheard en banc at the earliest possible date. Now, the county had actually argued for en banc from the get-go, like as part of the appeal, which is pretty unusual. They say that request was denied, but denied as moot because the judges are doing it anyway. So that was on November 10th, 2023, that was requested. Now, a circuit court can have en banc, can call for en banc without the losing party asking for it. That happens sometimes. They usually don't put it in the opinion, but they put it in the opinion here. And then there was en banc review granted shortly thereafter. I think it was 2 or 3. I don't have that in front of me, but a week or two after. There also then was a request for a stay of the district court's ruling. So the district court issued an injunction saying, okay, the old map or the map that was redrawn, that violates the Voting Rights Act. And so we're going to instead do it this way. So that judgment was affirmed by the 3-judge panel. But then once the en banc court gets involved on the 7th of December, they say, no, that order is stayed. So they haven't said the district court is reversed, but they're saying that injunction is stayed. It's no longer in effect. And so what does that mean? That means the upcoming election next fall, unless the en banc process works itself out quick enough, they're going to be voting districts under the map that was redrawn after the last census, the one that the district judge found was illegal. And that's why the writing's on the wall for all kinds of reasons. The 3-judge panel thought that the law would be changed. So if it got en banc, it seems like the law would be changed if they agreed with the 3-judge panel. Well, there were 9 judges who not only wanted en banc review, but want to stay this order. So everyone can see where this is going. So there were nine judges who voted, and that's a majority of the circuit, who voted for the stay. There were 4 judges that dissented from that noted their dissent from the stay. And there's other concurrences even that we don't need to get in the weeds of all of them. But essentially what's being argued about, there's a lead concurrence by Judge Oldham that has 1, 2, 3, 4, 5, 6, 7, 8, 9. Well, 9 in the concurrence even. I haven't looked if it's exactly the same. So 9 in the concurrence.
I think Judge Ho wasn't in that concurrence.
Right. Judge Ho was not in that concurrence, but he was separate. So that's, I said 9 earlier. There was 9 in this concurrence, which is a majority. So this is basically like a majority opinion of the Fifth Circuit en banc. Then you have Judge Ho concurring for reasons I'll get to in a moment. But anyway, you see a majority are for the stay. And they say that the reason for the stay, even though they haven't gotten to the merits yet, is because of this thing called the Purcell principle. Purcell principle is it seems flexible principle to me, but essentially it's that named of this case from 2006 by the Supreme Court that says federal courts shouldn't get involved in with elections, especially as you get close to the election. So you can rule on whether or not a state law is unconstitutional that comes with the election or violates the Voting Rights Act, but you shouldn't be in a rush to do it before the next election because there's settled expectations. We want orderliness with our election. This was a big deal as they pointed out in the various opinions have pointed out in the 2020 election, where we had all this COVID litigation and all kinds of other aspects to that litigation at that time. And so they say, well, we want to hold back here because of Purcell. The dissent doesn't like that. But then one split between the judges also is that they scheduled this for en banc argument in May. So that's in 6 months, basically. And Judge Ho and his concurrence, and then also the dissenters are like, okay, this seems like a big deal. Can't we do it a lot faster? Like, we can move fast when we want to. And the chief judge concurs and says, Chief Judge Richmond, she concurs and says, well, we're all full up in the next sitting in January. And so anyway, you can see there's some internal stuff going on there about the court practices. But essentially they say, no, we're going to do this in May. And of course, if they do it in May, God knows when the ruling will be. Maybe it'll be for the November election. But even if it is, that's probably not going to change it for that election. So really, this isn't going to apply till the election after that. And, the next census is in 2030. It's not that far away at this point, 6 years once they have argument. And so it shows you a couple things. Well, one is that election litigation can be super fast, or it can take a long time for the result to occur and get the result you want. And then the other is that when a Court of Appeals wants to change its law, it can change its law. It can do so quite quickly, and it can, as a practical matter, do so quite quickly. Now, I should bring up one other thing, which is that just a few days ago, there was a ruling in an IJ case that we will talk about on Short Circuit sooner or later. It was opinion by Judge Willett, and it was about a challenge we had to a use of a Texas prosecutor who was moonlighting as a clerk for the judge that he was before, and our client had got wrapped up in that and had a conviction, and because of this shenanigans going on in the court. And Judge Willett did not outright say that there should be en banc review in this case, but being pretty close. So we will see where that comes, and that has to do with interpreting what's called the Heck bar, which we won't get in the weeds of now, but it's an interesting other aspect of what the Fifth Circuit is up to. I've talked enough, Joe, but any shenanigans that you think merit mention in the Fifth Circuit?
Yeah, I mean, I think there are a couple interesting things about this case. I think the first one is that the case itself, I didn't check and see exactly when it was filed, but looking at the district court docket number and just looking that it's kind of a smaller number, it looks like it was filed in early 2022. And so I don't think it was exactly like necessarily that the plaintiffs themselves waited until the last minute.
Not at all.
This. I mean, they've been litigating this now probably for very close to 2 years.
Yeah, and you can't file it till the new map comes out. And exactly. And so I have no reason to think they weren't, lickety split on that.
Right, exactly. And then the city, it's Galveston County, I guess it is. It had made this initial motion to hear this en banc to begin with. Judge Ho has this idea that maybe the en banc panel, or whatever you would call it, a poll could have authorized the panel to just decide it as an original matter, disregarding the earlier precedent. Another alternative, as you mentioned, they discussed whether they could have tried to hear it in the January en banc sitting. It just really seems like there were a lot of steps along the way where perhaps the Fifth Circuit could have moved this along a little bit faster. So like if they can't hear it until the May en banc sitting, maybe the solution was to not have this initial panel decision complaining about wanting to call for en banc review. Maybe they could have just started with en banc review as Galveston asked.
Yeah, and one interesting part of that is maybe it is Judge Ho. There's an interesting footnote that says that there is a procedure for, I'm trying to find it here. There is a procedure for a circuit reversing, nullifying an earlier precedent and not going en banc as long as all of the judges or majority of the judges sign off on it. So basically it's like you pass it around the office to all the judges. You don't actually have an en banc hearing, and they say, yeah, you can do that. And then you're authorized to, a 3-judge panel is authorized to overrule a previous panel decision. And why didn't we do it here? Is the question.
And I've seen that in other court systems, like in the state court system. I didn't know that was an option in the Fifth Circuit or some of these circuit court of appeals in the federal system. But it seems like they're kind of facing a trade-off here, which is, do you want to have like a very drawn out, weighty, considered decision about this, probably what is, I assume, a pretty important substantive issue, which is how you were interpreting the Voting Rights Act? Or do you want to try to have a faster decision that's going to resolve these issues kind of in time to not mess up the election that's happening here? And part of the debates here are, it's surprising how much the debate here does involve kind of how fast to go with this case. Because as some of the concurrences in the dissents note, maybe you could do this in January and you could try to get a decision out pretty quickly. But I think the lead concurrence points out that the candidates have already declared earlier this month, declared themselves as candidates for primaries in these districts. And
those districts are gone now for the next year, it seems.
Yeah. Well, so I think they must have, it was after this decision, a couple days after this decision, I think was the deadline to declare yourself as a primary candidate. And so if you have a January en banc sitting, you're sort of almost to the primary, and you've already had people who have started campaigning in specific districts. They've declared themselves for specific districts. And so are we already too close to these elections, which are ultimately the November 2024 election? Are we already too close for those? And so this Purcell principle should apply and we should just leave the map as it is? Or does the dissent have it right? And November 2024 is actually the date we really care about. And maybe the court should just try to decide this now and decide on the right map once and for all beforehand. So I think that's kind of an interesting question and an interesting debate that the concurrence and dissent had.
Yeah, it reminds me a lot, I'm sure a lot of listeners, of the debates about, the shadow docket at the Supreme Court, where we need to make a ruling quick. That's important outside of the elections context, of course. And sometimes it seems like, certain justices are into deciding things quick over having all the deliberation that you get out of full briefing and or argument, all that. And sometimes other justices are more into having that lengthy time. And often, of course, it seems to change on the issue, which justices are complaining about what. And we are very much about to see how things go fast or how things don't go fast with a couple issues related to our former president, both his prosecution and his now apparently not going to be on the ballot in Colorado. And that's going to be, a lot of that is going to be wrapped up on these issues. And that, of course, is going to be a federal court saying something about an election. But
yeah, I'm just sad those aren't in the circuit courts, so we don't have an occasion to talk about at least the Colorado.
Yes, yeah,
decision.
we will not be weighing into too much on those issues. We've said a few things about them already in tangential ways.
One interesting question is that I think also comes up is if you're not applying the Purcell, there is also this debate about, is the likelihood of success on the merits kind of a factor that you consider in this decision? And then, and some say yes and some say no. Some say it's just whether it's too close to the election. And then the other interesting aspect of that was, if you do consider likelihood of success on the merits, like, what is your framework? Is it existing law, or is it what you predict that law is going to be as a result of your en banc review?
Right.
Because if it's existing law, obviously the law is quite clear that Galveston loses and you have to change the maps. But if you're kind of reading, as you say, the writing on the wall and counting up these concurring votes, you kind of know where the en banc
including
is heading.
Including at this point what the per curiam, the 3-judge panel this year said. I mean, they lay out their theory of the law, and then they're like, well, but we can't say that because we're bound. I mean, I think in some ways it's kind of a remarkable thing, little opinion, because they say, so this, I read the end earlier, but this is from in the middle of the opinion. So they're talking about the district court and how the district court applied existing precedent. And then they say, but the court's decisions, meaning the Fifth Circuit, so it's prior decisions, the court's decisions in this respect are wrong as a matter of law. And you wonder, what do they mean by, we all do this, but what do they mean by law? I mean, quote, the
Right.
law is the Fifth Circuit precedent, right? Or is the law the text of the VRA, or is it something else? Is it a mixture of a bunch of things? Well, there apparently they mean matter of law. They mean, I think, the text of the statute itself. But
I think it's maybe a Minority Report situation where they maybe foresee something that's going to happen in the law very soon here.
yeah. Well, and they're probably not wrong about that, as we have said. So, well, thank you for joining me today, Joe. And thank you to the listeners for listening to both of us and our cases. Happy New Year to all of you. I hope you have enjoyed our year of, I think we've had 52 episodes of Short Circuit this year. And we'll look forward to more Short Circuit next year. Some Short Circuit Lives coming up, some other fun stuff. Of course, keep listening for Bound by Oath. But in the meantime, I want to not only ask you to have a happy new year, but also ask you to get engaged.